Hello, everyone, and welcome to the webinar. My name is Erin, and I am an estate planning attorney and the founder of Noble's Law. I'm really glad that you're here today to spend the next 30 minutes or so with us to talk about estate planning for parents. Um, at Noble's Law, we specialize in estate and legacy planning for families with children under the age of 25. Um, However, if you don't have children or if your children are not under 25, I hope you'll stick with us today because I think we're going to have some really great information for you. All right, so let's go ahead and get started. Okay, so first of all, a little housekeeping. If you wouldn't mind, please mute your line if you're here live with us. Feel free to use the chat for your questions and for your comments. I may not respond to them right away, but I will have the opportunity at the end to answer some of your questions, and we'll stay a little longer if that needs to be done. Now, if you can't stay till the end, or if you don't want to hang out a little longer, or if you're just not comfortable asking your question in the chat, please feel free to email me your questions directly. So that's erin@nobleslaw.org for follow-up. And however, if you are able to stay till the end of the presentation today, you will get a special offer that is good today. So as my way of saying thank you for hanging out until the end. All right, so let's get started. Okay, on our agenda today, we're going to spend a little bit of time just talking generally about what estate planning is. And maybe a little bit about what it's not, but mostly what is estate planning. We'll talk a little bit about a will versus a trust. This is something I'm asked all the time. Do I need a trust? If I do want a trust, is that something that I have in addition to my will or in lieu of my will? So we'll talk about that. Then we're going to talk a little bit about one of my favorite issues, and that is who you should name as the beneficiary of your accounts. Like, what does it mean to name a beneficiary? What's the benefits to doing so? And what also might some of the limitations be and why? And then lastly, the question that's always on everyone's mind, what should estate planning cost? What should estate planning cost me? And also the companion question is, what does estate planning save my family in the long run? All right, so our first question, what is estate planning? So I like to answer that estate planning is really a plan for life, not death. When we think estate planning, think about a will, and that's something that only comes into play after we've died, and we don't typically like to think about our death that much. But it might sound a little woo-woo, but I do think it's important to reframe the issue. Estate planning is not a plan just for your death, because once you've taken the time to think about your loved ones, your values, what your assets actually are, and you've put together a plan to make sure that your values are respected, your children are taken care of, and they're never exposed to creditors and predators. Once you've had the opportunity to make sure that your assets are gathered together in a way that's easy to understand and is distributed in a way that is reasonable, makes sense, and you're not losing assets to predators or unnecessarily to the government through excessive taxes. Once you've had the opportunity to go through that process and really think about that process, you have the ability to live your life with a little more peace because you know that you've done the best that you could for the people that you care about. So in that sense, estate planning, although it comes into play if you've been incapacitated or passed away, is really more about empowering you to live the kind of life that you want to live and not have to worry about what's going to happen to the people you love after you die. All right, so that's all well and good, but there are documents that are in an estate plan, and I think it's important to know kind of what those basic documents are. All right, so some common estate planning documents can include documents that are designed to be used during your lifetime, like your advance directive for healthcare, your power of attorney for finances, and maybe your living trust, as well as documents that, by their very definition, only come into play after you've died, like your last will, perhaps that emergency guardianship. All right. So just this is a very high level view, and something I spend a lot of time with my clients talking about and thinking about, but just very basically speaking, in the Commonwealth of Massachusetts, an advanced directive for healthcare is going to have 2 or 3 documents in it. The 2 documents it definitely will have in it is your healthcare proxy, where you have chosen someone and then hopefully some alternates if the first person is not available to make decisions for you if your doctor has determined that you are incapacitated and you're incapable of making those decisions for yourself. And this could be treatment decisions, this could be stopping treatment decisions, and other end of life decisions. A companion document to the proxy that names the person is going to be HIPAA authorization, because that gives your proxy the ability to see and to hear medical information that would otherwise be protected under the federal HIPAA statute. A third document that I typically include in most of my advanced directives, although it's not strictly speaking part of a Massachusetts advanced directive, is a living will. A living will is a document that is not the same thing as your last will at all. A living will allows you to state the types of interventions that you would or wouldn't want. Now, in Massachusetts, your healthcare proxy can always override what you've put into a living will, and that's why some lawyers don't do them, because they say they're not enforceable. I do them because I think it's a good opportunity for you to state your wishes so that your proxy has something that they can refer to if they're ever in that decision making situation. Of course, you should talk to your proxy in advance about what you would and wouldn't want done, but having that living will, it's just more information for them, especially if there are other members of your family that might challenge the decisions that the proxy is making. Okay, so number 2, this is the second document that really becomes part of most estate plans, and that's a power of attorney for finances. Now, a power of attorney allows you to nominate an agent, and again, some alternates, who would be making financial decisions for you. So this typically comes into play if you're having some capacity issues, and it enables that agent to help you pay your bills, maybe to close bank accounts that are not serving you well, to sell vehicles or things that would need to be liquidated in order to position you perhaps for long-term care. The power of attorney does that. Now, this is estate planning for parents, for us as parents, but it's always a good idea to have a conversation with your parents as they move into their 70s. Do they have a power of attorney for finances? Because chances are it's going to be you or one of your siblings, maybe falling into that role of being that decision maker. And by the time they've lost enough capacity for you to need that power of attorney document, they can't execute one if they don't have it. So it's really important to have that conversation and to kind of normalize those sorts of conversations with our parents. But because we never know what the future can bring, it's important for even a young person to have the power of attorney for finances in their cachet of estate planning documents. All right, so number 3, I think, is the document that everybody thinks of when they think about estate planning, and that's the last will. It's important to note that having a last will is only effective after 2 things have happened. Number 1, the person who wrote it has died, and then number 2, the document has been presented to a judge or a magistrate, and they have actually approved the document. So just having a last will doesn't really do any good for your family unless and until it has been approved by a judge. And that's a really important concept because people sometimes think, oh, if I have a will, I can skip my family can skip having to go through that probate court process. And that's not actually true. By definition, a will is something that has to go through the probate court. So oftentimes, families will create a living trust as a companion document to that last will, because a living trust is a document that is immediately effective and doesn't have to go through that probate court process. So we talked about, so I said I was going to mention the difference between a last will and a living trust. And that's really a core difference, is that the last will disposes of property and appoints a guardian for your children, but it has to go through court. Whereas a living trust can help you manage the property that you're leaving behind in a document that is completely private and doesn't have to go through court. All right, if you do have minor children too, the document that I skipped over, the emergency guardianship, is something that you're going to want to have on hand to make an emergency appointment of a guardian for your child. Now, in Massachusetts, there's actually a statute on point that allows this. In some states, it's less clear, but in Massachusetts, an emergency guardianship can be used to delegate your guardianship authority for a limited period of time. All right, so let's talk a little bit about what happens if you don't do anything. If you pass away without an estate plan. The Commonwealth does have a plan for you. All states have statutes. Those are specific written laws that govern how your assets will be distributed in the event that you die and you haven't made any plans for the way that that should happen. In Massachusetts, that's the statute of intestacy, Massachusetts General Laws, Chapter 190B, starting at Section 2-201. Very prescribed, not a lot of wiggle room, but it does clearly state who your heirs would be under certain circumstances, who's entitled to information about what your estate is comprised of, as well as very specific instructions for how property is to be distributed. All right, and the statute of intestacy is administered through the probate and family court, exactly the same court system that manages the administration of a last will and testament. So whether you have a last will and testament or you die intestate, you're going to have to go through that probate court process. So let's talk about that. All right, so when someone passes away, it can be somewhat unclear what should happen to their property, their real estate, their investments, their bank account, their personal property. And that's what the probate court is designed to do, provide that clarity. The probate court is also designed for the benefit of creditors to make sure that they have the opportunity to get debts that were owed to them by someone who passed away repaid. So when someone passes away, someone must come forward to marshal, what they call it, marshaling the estate. And that means kind of getting everything organized. So figuring out where the accounts were there beneficiaries named on the accounts, who the potential heirs are, people who should inherit the property. The person, anyone, can be chosen to be the personal representative. If you've written a will, you've probably chosen who you want that person to be. But if you haven't, if you've died intestate, then anyone can come forward seeking to be that personal representative and manage your estate. That person is going to meet with a lawyer, and in conjunction with that lawyer, they'll actually file a petition. It's very specific. It's got pretty good level of detail in it, and so it's usually a pretty good idea to hire a lawyer to help you with that. Once they've got information that they need in the petition, plus your death certificate, will if you have it, information, perhaps permission from your heirs for that personal representative to serve, they'll file that petition with the court. A judge will review it, see if everything makes sense, and then hopefully, if it all does make sense, appoint that person as the personal representative. Now, from that day on, it's a public process going through probate, notices in the newspaper, filings with the court, all of which anyone who wants information about the estate can have access to. Assets are frozen during the time that the probate process is going on, which means that absent special permission, you're not able to sell personal property, real estate, or anything that had belonged to that decedent, because we want to make sure that there's enough money kept in the estate to pay any creditors who come forward or to pay any taxes that might be due. So you'll see here it says time, however long it takes, and that's a little cheeky, but typically it's going to take between 12 to 18 months to get everything sorted out and then to start to determine whether the estate is solvent, where it can pay out to the heirs, or insolvent, where there's not enough money to pay back the creditors and then make a distribution to the heirs. So at least a year, often longer. Fees typically are 2.5% to 3% of the value of the estate. And those are attorney's fees, appraisal fees, court costs, all sorts of things that have to happen before you can resolve that case. So it is important to note that if you have not named a guardian in a will, or even if you have named a guardian in a will, the probate court and a probate court judge will be the ultimate entity that determines who the guardians will be. So if there's no nomination, if you've made no nomination, the court will entertain nominations or requests from other people to be guardian. There's no clear track for who should be the guardian of your child, obviously other than the child's other parent. But if both parents have passed or there's only one parent actively parenting, the court is going to make that decision. Now, if you've nominated a guardian in a will or in an emergency guardianship or something like that, it is persuasive evidence. So unless it's not in the best interest of the child to follow that guidance, that's what's going to happen. But it's really, really important to realize that if you don't choose a guardian, there may be multiple people coming forward who want to take your child. And the court's going to have to settle. The court's going to have to figure it all out. And that can be a long and pretty traumatic process for children. So certainly make sure if you're a parent that that's something that is at the top of your to-do list. All right. So when I'm planning with parents, I really think guardianship piece is fundamental. And I look at it from as a 3-step process for protecting parents. And the first step is really to figure out who would be a good emergency temporary guardian. Now, that's someone who I say is hyperlocal. That's somebody who can step in within about 30 minutes or so to prevent a nightmare scenario where you and your partner have gone out to dinner, had a terrible car accident on the way home. You don't show up and the babysitter doesn't know what to do, so she panics and calls the police. The police don't have any documentation with respect to who is authorized to take your child. Your neighbor says, oh, I have a very close relationship with them. They're over here all the time. And it would make sense, but she's not a blood relative. And so the police, absent authorization from you, are certainly not going to leave your children with your neighbor. They may not leave them with a relative. It is, definitely something that would be evaluated on a case-by-case basis. But if you have nominated that emergency temporary guardianship, that's going to be good in Massachusetts for a reasonably long period of time, up to 60 days. And so somebody's going to be able to step in right away. Fundamental planning for parents part 2 is a will to choose that permanent guardian, to give the court help in making a determination about who should be the person raising your children in your absence. And then fundamental planning step 3 is to create that trust, to structure any financial distributions that need to be made to the guardian. So your assets from all of your different investment accounts, bank accounts, your home, all of those things would flow into a structured account that would be kept separate from the will and what's going through the court system. But it would structure how those assets were to be distributed to the guardian during the children's childhood, and then hopefully the nest egg that's left over after that would be delivered to them as adults in a smart and thoughtful way. All right, so I said that I was going to talk a little bit about beneficiary designations because you may know that when you get a new job and you start a 401k, you open a bank account, you buy a policy of life insurance. One of the questions that you're asked is, who do you want to be your beneficiary? And this is what I'm talking about when I say beneficiary designations. You can choose a beneficiary for almost any type of account. And once you've made that beneficiary designation, that asset is not going to have to go through probate. It's just going to go, usually it's not going to have to go through probate. It's just going to go automatically to that person that you've chosen as your beneficiary. It's important to notice that if you make a beneficiary designation, that designation is going to supersede whatever you've put into your will or your trust. And this is important to think about. If you started a job prior to your marriage and your 401k names your mother as the beneficiary, then you get married and don't change it to your wife, even though your will or your trust says that your assets should go to your wife, that particular asset where you've named your mom as the beneficiary is going to go to your mother. So it's something important to be aware of. And lastly, a beneficiary designation is an outright gift. If you leave that 401k to your mom or your sister, then it goes to them, no strings attached. And I say that because typically a beneficiary designation can be a very powerful thing, but you never want to name a minor child as a beneficiary of any account. And the reason for that is that they cannot possess those sorts of accounts. So typically the court is going to need to get involved to appoint a conservator, and who knows who that's going to be, to manage those funds. And then those funds are given outright to your child when they reach the age of majority. With no restrictions, like you might have put in a trust, that they would only get a certain percentage at age 25, then they'd get the balance at age 30. You're not able to do that with a beneficiary designation. So the entire amount would go right to that beneficiary as soon as they have the legal ability to possess those funds. All right, so the final question that I said I was going to get into was, what is all of this going to cost me? What does estate planning cost? And I've really kind of broken down 3 options. Or here, how much money could this save my children, save my family? So option 1 is to do nothing. That's always an option. If you choose not to decide, you still have made a choice. And doing nothing is the cheapest for you, but it's the most expensive for your loved ones. And the reason is, if you don't do anything and you die owning something, it's pretty much guaranteed that there's going to be some probate court exposure. Lastly, if you don't do anything, it's likely that your assets are not going to be organized. So it's likely that assets will be lost because the people trying to pick up the pieces and put together your estate aren't going to know about them or how to find them. Now, as I said before, probate's usually about 2.5–3% of your assets. So a $500,000 estate, which, is pretty standard, could end up costing your children $25,000 in probate fees alone. Now, if your family ends up owing Massachusetts estate tax, or if your estate ends up owing Massachusetts estate tax, that could be much, much higher. Option number 2 would be to create a do-it-yourself will or work with what I call a generalist attorney. And that's an attorney who does a number of things. Maybe they do some family law, maybe they do some real estate, a little bankruptcy, and then they do wills and trusts for their other clients. An attorney is going to be on the higher end of the range. Do it yourself could be as cheap as $300, or heck, free will, it could cost you nothing. So this seems like this is less expensive for you, but actually if your plan doesn't work because you didn't know what you didn't know or mistakes were made, this could be just as expensive for your loved ones as doing nothing. Plus you have paid something. So this, I think, is actually the most expensive option. Sometimes problems can be that the plans that are put in place are very cookie cutter. Either the DIY doesn't have a lot of options, or the attorney just doesn't know about it. They know about the options that they have because it's not something that they focus on. Also, even if everything is done correctly and you make a mistake in execution, that can invalidate everything. And I've seen that a number of times where a will isn't notarized or it's not witnessed properly, or one of the witnesses is an improper witness. And even though it seemed like it was done pretty well, having that simple mistake invalidated the whole will. So whether they paid $300 or $3,000, they might as well have not done anything. All right, so option 3 is to work with a personal family lawyer like me. Now, I use all flat fee billing. Many estate planning attorneys are using this model now. It used to be an hourly fee, but I and many attorneys who focus on this area have moved into flat fee billing. So we look at your assets, we look at the complexity, and we determine a flat fee for organizing your assets, for creating the documents, and then for monitoring the plan as we go forward. And at our firm, it's usually, between about 3,500 to about 6,500, depending on the complexity of what you need once we've had the opportunity to review. Now, we do a lot of trusts at our firm, and for some of the reasons that I talked about before. And so this does increase the cost to you, but it makes it much less expensive and much more simple for your children. And they have access to your money quickly, privately. We also do write in plans for incapacity. We make sure that we've built the strongest case when there's an issue with guardianship, maybe somebody that you fear would come forward. And even though they look good on paper, they're not the right person. So we definitely go through that process of making sure that we've made your choice as enforceable as possible. Additionally, we stay in touch with you throughout your lifetime so that if you are having to make changes, you're not starting over from scratch. And I promised that if you stayed till the end, you would get a reward. And the reward is that you do not get a consultation with me. Instead, you have the option to schedule what I call the Family Wealth Planning Session. At the Family Wealth Planning Session, we really do a deep dive. So I've sent you a link to a private, secure website where you can provide me with some information about your family, your goals, your assets. And then we go through that and we talk about what the status quo would be under Massachusetts law. And then we talk about, things that we can do to make sure that your vision is what actually happens and not the default. If this sounds good to you, I have an additional incentive to have you schedule, and as a thank you for being here today. And that is that I would like to offer this meeting to you at absolutely no charge. Now, typically, I charge $750 because I've reviewed your information, I've put together some information for you, and I've kind of walked you through the process of getting your plan set up. But you've been here today and you've learned a little bit about the estate planning process. So I'd like to offer you that family wealth planning session for a zero planning fee. And in addition to that, if you go ahead and book with me using either of the links that you see here on your screen, by the end of our session today, you will get an additional $250 off any planning that you do with us. Now, I have been informed that these links do not work. So I'm going to go ahead and stick them in the chat so that you can book. So that you can book those right away. If you're not quite ready to book, you can go to my website at www.nobleslaw.org and learn more about me. You can book a 15-minute consultation, or you can go ahead and book the family wealth planning session with me directly on my website. Now, if you wait too long, I might not be able to give you the additional $250 off. So if you want that golden ticket, I would suggest you go ahead and link to that, and I'll show you those again. So, so that you can get the benefit of that, and you can book online, and you'll see a whole range of dates and times when we're available. So you should be able to find something that fits with your schedule. If you don't, you can certainly always email me, let me know that you watched this video, and we can go ahead and get you in. All right, so let me just take a quick peek and see what I've got for questions and questions that have been submitted to me before. I've got a few. All right, so number one, what happens to my estate plan if I move out of Massachusetts? This is a really good question. Um, and the good news is that due to the full faith and credit of the US Constitution, your estate plan that was legally enforceable when you created it in Massachusetts is going to be legally enforceable in any state in the United States where you live. So you don't need to worry that you've written the Massachusetts estate plan and now you've moved to New Hampshire and you have to start over. That is not the case. It's a good idea to make sure that your estate plan is customized to the state where you live. So if you've come here from Virginia, it's a good idea to review your estate plan to make sure that it is consistent with Massachusetts law, especially Massachusetts estate tax law, which is unique and a little bit different than other jurisdictions. But it's not fatal if you move from one state to another and you don't have a chance to change your plan right away. It's still enforceable. All right, let's see. Can my guardian be a non-US citizen? So this is a really good question. So as a threshold issue, I think that temporary emergency guardian should be somebody who is hyperlocal, could get to your house really, really quickly, to avoid, any disruptions in who your children are with. In an emergency with kids, it's important to have as much consistency as possible. So they don't have to be US citizens, but they should be somebody, living close to you in Massachusetts. Now, there is not any sort of bright line rule for a permanent guardian as to whether they can or cannot be US citizens, or if they live abroad. Let's say that your parents live in Ireland, and you want to name them as your guardian, you certainly may do so. Now, because a judge is going to have to make that final determination regarding what's in the best interest of the child, I do always tell my families that if you're going to do something like that, it is really important, and really just from a parenting standpoint, it's important to make sure that your children have a relationship with that person who would be in that guardianship role. And again, that's for continuity. You don't want to have them go live with your brother in Australia when they don't know your brother and they've never been to Australia. You want to make sure that you're presenting a compelling argument to the court about why they should place your child with that person. And of course, you want your child to have a smooth transition, so you would want them to have a relationship with that person. But there's no hard and fast rule that person must be a US citizen or reside here in the United States. All right, let's see. Do I have any others? Okay. So does my personal representative, executor of my will, need to be a lawyer? The answer to that is no. Usually someone will pick their surviving spouse, and then they'll pick another person or two, a parent, a sibling, a trusted friend, maybe an adult child, to be in that role. So it's absolutely not necessary for that person to be a lawyer. That person will probably hire a lawyer to help them go through that process. But certainly they themselves don't need to have any special medical or special legal training. All right. Okay. All right. So this looks like all the questions that I have in the chat, and that's good because we are out of time. I hope that you have enjoyed this. I hope that it's been some useful information for you. Again, I would just encourage you to schedule that planning session so that you can get the benefit of that full $1,000 golden ticket. If you have questions, please feel free to email me at erin@nobleslaw.org. Visit us on our website. We've got all sorts of resources on our website, blogs about many different issues related to parenting and estate planning. So I hope that you will check that out. And again, thank you so much for sharing your lunch hour with Noble's Law. I really appreciate everyone being here today. Thank you.